Justice Jackson?
I have to say, I think that the arguments and assertions in this case are all over the map and very hard to follow. So I'm trying to understand how and to what extent the district court erred in this case, given the law as it existed at the time the district court ruled, as opposed to the law that Alabama wishes it had enacted or the cases that it wishes it had already put into place with respect to standards that it's coming up with now. So I understood you to say that there were two errors, something about likelihood or possibility versus possibility. And the second is the one I'm most focused on, which is that under Alabama law, you understand that the law is and was at the time of the district court that if you're looking at secondary evidence, was the secondary evidence strong enough to drag down what you had gleaned previously from the IQ scores? Is that what you understood Alabama law to be, and therefore it was an error for the district court not to apply it?
Yeah, and I don't think it's an IQ-specific insight. I think it's just a common sense point about the nature of how preponderance
I just want to know if it
work.
existed as a standard so that we could say the district court erred.
Yeah, I think that when you need to show that a fact is more likely than not in light of the totality of the evidence, you can't then exclude the most probative evidence as part of that weighing. So the issue here that the district court did is it said that the IQ scores allowed it to move on to other evidence, but then it forgot about the first half of the scale. It never looked at the collective weight of the IQ scores all above 50 to
But
see.
it did entertain expert testimony, and this is the second part of my question to you, is I'm trying to understand, there is a nub of this that's a question of fact, right? Is this person intellectually disabled? And I don't take it that you disagree that experts are going to be involved somehow in making this assessment, right?
Right.
They're not only testing, but they're also looking at other evidence to the extent courts allow them to. So what I understood happened in this case is we had a series of experts come in, evaluate not only the test scores, but also the other evidence, and testify as to whether or not they thought this person had an intellectual disability. Now, I appreciate that the state's experts said no, but the other experts said yes. And the court looked at that and made a decision. I don't understand why that's error from the court's perspective when we ordinarily allow for hearings with evidence and testimony that goes to issues of fact, and the court decides.
Right. So I wouldn't think about this as a battle of the experts cases.
But why not? We had experts who testified to this issue.
That's the part where I disagree with you. No expert testified to whether or not respondent satisfied his burden at prong one as understood by Alabama law. All of the evidence about intellectual functioning was measured against clinical definitions that are different in kind from what Alabama asks. So again, the experts offered in their insights.
Okay, can you point to a case in which Alabama says experts, you can only testify for the purpose of our law to the standard as we are now articulating it? Because to the extent that Alabama sat there and heard the experts testifying and didn't object on the basis that you're saying, or didn't argue to the district court, there's a problem with this testimony because he's testifying to things that Alabama law doesn't consider, I think you may have waived this.
I think the basic point is that it's not an all or nothing inquiry either way.
I'm just trying to understand what was argued below. If you're now saying the problem with the testimony before the district court of the experts is that it wasn't focused in the way that Alabama law requires, where's the objection from Alabama below saying that?
The fact that it doesn't answer the entire legal analysis or legal question before the district court does not mean the expert testimony is not relevant. But the district court then needs to take that evidence, put it into the equation as structured by Alabama law. So what I mean by that is that it is true that the experts said, well, the secondary evidence has a bit of a downward pull, but that is—
The expert did say that.
But that is the start, not the end of the analysis. And that's the key problem with the district court, is that it never looked back to see the weight of the thing that it is pulling. Because essentially what it said is this downward pull is dispositive. It never returned to the collective weight of the IQ scores as part of that analysis.
Thank you.